Good day and welcome again to Employment Law Show. John Scholes here alongside, of course, Lior Samfiru. You want to reach out anytime because after this 30-minute show, you're going to probably have questions you want to ask after the show. So that is not a problem. 1-855-821-5900. help@employmentlawyer.ca is the email address. And we will refer to several times today. Lior, we got lots going on the show today. In fact, what your family and friends need to know about employment law, that is on the way. But we always start every show with the week that was. How are you, pal?
John, really busy time in my office. Sometimes I don't even know if I'm coming or going. Just a lot of volume of questions that I'm dealing with, my team is dealing with. But please keep them coming because I know these are important issues. These are difficult times for so many. I have never in 20 years of practice have seen so many issues about employment law come up in such a short period of time. So that's why we do this show, to reach as many people as possible, to inform you and educate you about your legal rights when it comes to this very important thing called your job, your employment. So if you wanted to know, you've always wondered, you've always had questions about what your rights are or can your employer do something, that is the theme, that is the point of this show. That's exactly what we talk about. And of course, if we don't get to cover your question, your concern on the show, not a big deal. Option number 2 is just as good, and that is you can contact me in the office anytime to talk privately and in person about your situation. We'll give you that contact information. But now that we know what we're here to talk about, let's get to it. Let's talk about a situation that came across my desk very recently. I spoke with a lady who had worked for a large retailer. They'll remain nameless. Unfortunately, a new boss that came, a new manager, started mistreating her. She considered that to be bullying. There were threats made about her job, about her security, workplace security. And ultimately, things got so bad that she had to go off on a medical leave. While on a medical leave, she told her employer about this. She said, please investigate, please do something about it. And in fact, even her doctor said that she should not be going back to work until this is resolved. Well, when she was ready to come back to work, she asked her employer, have you looked into this? Can I assume that things are going to be hopefully better once I'm back? Her employer said, well, no, we haven't. We'll look into it once you come back to work, and then we'll see what needs to be done. Well, she wasn't comfortable doing that for obvious reasons, and she called me. And she wanted to know, well, what do I do here? I want to go back to work, but my employer hasn't done anything about this poison work environment, about the harassment that I was facing. Do I even have to go back to work? Well, John, this employer dropped the ball. As soon as they became aware that there's an issue, they should have immediately investigated that issue. They should have asked the right questions of the right people, found out exactly what happened, and then, of course, take measures to resolve the issue. It's not acceptable to tell an employee that's been off work because of stress related to harassment, come back to work and we'll figure it out later. It doesn't work that way. The employer has an obligation to have a safe work environment, and that means dealing with bullying, dealing with harassment, dealing with these things when you become aware of them, not later, now when it's convenient. So this employer, in dropping the ball, as I said, essentially they've constructively dismissed this employee. They've shown that they're not willing to provide her with a healthy work environment. She can treat this as a termination. It's potentially a human rights violation. I'm going to help her get the compensation that she's owed. But I wanted to remind everyone, employees and employers, that when it comes to workplace harassment, when it comes to bullying, when it comes to being in a situation that's improper, the employer has to do something about it. The employee should advise the employer, and the employer has to act quickly. Not a year down the road, not when it's convenient, now. And if the employer doesn't do that, yes, John, there's going to be legal consequences.
Okay, question number 1, what if the person, maybe it's a small company, maybe a little mom and pop corner shop. What if the person doing the bullying that you would report to is the one doing the bullying? Some people are going to feel helpless. What's your next step?
Well, if there's no one to complain to, right, if there's no one to investigate, because you'd be investigating yourself in that situation, then you can't deal with that in that situation. You can't really try to fix the work environment. At that point, the only recourse is to try to get the person out of there and get them the compensation that they're owed. So yes, if you can't have a complaint made because your boss is, or the owner of the company is the one harassing you, talk to me, let me get you out of there so you don't have to deal with that stress, with that bullying, with that harassment.
This case was obvious, but if it's a case where it turns out that there is an investigation done, there's due diligence done by the company, and it turns out there was nothing that rises to that level, whether it's bullying or harassment, because she was wrong, or anybody's wrong for that matter, can they be let go because of that?
No. So that's a very important question. You cannot be let go for raising harassment allegations. Full
Right.
stop. There's no exceptions to that. Even if it turns out that you couldn't substantiate it, even if it turns out that the company was not able to conclude that it actually happened, they cannot penalize you in any way, shape, or form for bringing it up. That's illegal. You're protected. So you should always feel free to advocate for yourself when it comes to workplace harassment.
In addition to this TV show, of course, we have a long-running radio show. It's been about 8 years. We've been on radio across the country, pretty much coast to coast, or we're getting there anyway. And you want to tune into one of those shows weekly, several times a week, as a matter of fact. Employmentlawyer.ca is the website to go to. You'll find a list and links to find a station near you as well. As you know, Lior, we like to get some of the phone calls we get on those radio shows, play them back here, and we dissect them and give out more information in that regard. So I want to get to the first phone call from our radio show right now.
The company I work for, it really looks like they're going to be closing down in the next, let's say, 6 months. I've been there 28 years, and I'm wondering what kind of severance package I would be entitled to.
How old are you?
I'm 60.
And what do you do there? What's your position with the company?
I'm a shipper. I drive a tow motor.
A nice package. Yeah.
Yeah. The answer is they owe you a lot. But let's break this down even more than that. So the fact that the company is closing, they're shutting down, they're essentially going to stop operating, does not relieve them, okay? Does not relieve them from the obligation to pay severance. So closing down, cutting costs, deciding we're not going to operate does not relieve them from those obligations. They still have to pay the employee the same severance that they would in a normal situation. And of course, remember, the main factors that go into deciding how much severance are the person's age, their position, and the length of their employment. So yes, this person, after 28 years at the age of 60, is owed a substantial amount. So I can tell you right now how much he's owed, but let me show you how much he's owed. Let's take his information and let's plug that into our severance calculator. By the way, that severance calculator is available at pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. So when we go to the severance calculator on that page, you will see this person is a forklift operator. You see on that screen, been there for 28 years. We know that he's 60 years old. Well, he's owed anywhere from 18 to 24 months of severance. See that there, up to 24 months pay. Obviously, depending on his compensation, that could be well into the six figures. So that's what's at stake for him. And the lesson here is shutting down, stopping to operate does not deprive you of your severance, not at all.
Now that is different from a company that is shutting down via bankruptcy. That's a different animal, right?
Absolutely, and that's a very important point. If the company closes down, if they're going to shut their doors, that does not mean that they're in formal bankruptcy proceedings. Only a very, very, very small portion of employers that shut down are actually in bankruptcy. If a company is in bankruptcy, the reality is that the employee is not likely to get very much. But them shutting down, the company stopping to operate, does not mean bankruptcy. And if they're not in bankruptcy proceedings, they have to pay you your full severance.
Another resource is terminationquestions.com. You can do exactly that. Go there and ask your questions about termination and employment law, and we'll answer them either off air or we get to some here on this show. Lior, first one for today is from Marcella. Says, I've just been told that due to cost-cutting measures, I will be losing my job in 4 weeks after I train my replacement. They say they are not required to give me a severance package even after 12 years with the company. Is that correct?
Well, I think this is someone that, that company got their legal advice maybe on the back of a cereal box or something, because clearly that is nonsense. Clearly that's not even close. Now, even if she had worked there for 12 months or, 12 weeks, she would have been entitled to severance and a substantial amount. After 12 years, of course she's owed severance. Now, remember the usual factor, age, position, and length of employment. She could easily be owed a year's pay, even potentially more than that, depending on those factors. And the fact that she's training a replacement, again, that's not a convenient thing to do. It's not a nice thing. No one wants to train their replacement. There's nothing illegal about it. The issue here, of course, is one of severance. If you are let go, you have to get paid severance. I have no idea why this employer would believe that they can avoid paying it. You can't. It's simple. All you ask yourself is, did I lose my job? If the answer is yes, you have to get paid severance. And as I've said before, to find out right now, anonymously, for free, and in seconds, how much you're owed, just go to pocketemploymentlawyer.ca. You'll see our severance calculator tool there. Use it. Even if it's just something you've been wondering or curious about, check it out. You'll be surprised.
You know, and it's funny, a curious little sidebar to that story that we always like to mention from time to time is the reason for being let go. I mean, yeah, you can go in today and your employer says, you know, I don't like blue ties, so out you go. It's crazy, but as long as they pay you full and proper severance, they can actually do that.
And that is why when we talk about losing your job, termination of employment, that's why you hear us use this word severance so often. That's why we focus on it. And we focus on it because that's what the law does. That's what the law focuses on. The law can't change your employer's mind. The law can't have your employer give a better reason. The only thing the law can ensure is that you get the severance that you're owed if you lost your job. Your employer, as John said, can let you go at any time and pretty much for any reason, but they have to pay you your full severance. Remember, that severance can be as much as 24 months' pay, and over 90% of people, when they're let go, are offered less than what they're owed. Now you've watched this show, now you know better, so it's not going to happen to you.
All right, coming up here, what your friends and family need to know about employment law rights. That is all on the way. First, we want to take a short break, and we'll get right back to it. In the meantime, 1-855-821-5900, the number, and help@employmentlawyer.ca for email. Coming right back, Employment Law Show. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back, Employment Law Show. I want to get into this, Lior. Things your family, friends, in fact, I'm going to broaden that to all of us should know about their employment rights. Now, as we go through a handful of these over the next few minutes, many of these may surprise a lot of people, right?
Yes, and the reason we're wanting to talk about this is that some things are just not obvious. Some things appear obvious, and the opposite is in fact true. And I know there's a lot of questions. I know you may get questions from your friends, from your family members. So we're going to give you some information for you to know about your workplace rights, to share with others, to spread the word about employment law and workplace rights. So these are very, very important points to keep in mind.
First one is this: your employer is not allowed to make changes to your job.
That's so important. It's always important, but it's especially important now during COVID-19. There's a lot of misconceptions out there. And one of the biggest ones is that now, because of COVID-19, my employer does have the right or has the flexibility to change my job. Maybe my employer can change my hours or change my pay or reduce my benefits. Well, let's be very clear. None of that is true. Your employer cannot change your terms of employment in a significant way. They cannot. That results in a constructive dismissal. This concept of a constructive dismissal is still here. It hasn't been eliminated or reduced because of COVID-19. Doesn't matter what province you're in, Alberta, BC, Ontario, the same thing applies to you. If you're now facing a change to the terms of your employment, your hours have been cut or your pay's been reduced, you can accept that pay change or that change if you want. You obviously can. It's your right. Or you can treat that as a constructive dismissal. You can say, I'm not accepting that, and instead, I'm going to get my full severance up to 24 months' pay. Remember, of course, that one of the risks or the problems with accepting a change a change that your employer otherwise is not allowed to make, is that by accepting it, you've given the company the right to do it again. So today it may be just a change, couple of hours here and there. Well, by allowing that to happen, that could become a much greater change later on. Maybe next month it's going to be 30% reduction or 70% reduction, and then you may not be able to do anything about it. So please remember that when it comes to changes, your employer cannot change terms of employment in a significant way.
Yeah, we often say, if you want to know if it passes a smell test, just flip it around. You can't say, you know what, you're going to pay me 50% more today, or I'm only going to work 20 hours instead of 40 this week because I want to. It doesn't work that way, right?
It doesn't. And, some people don't understand why this example is actually so apropos, but it really is. An employee can't go to the employer and say, well, I've decided that effective tomorrow, I'm going to work morning shifts instead of night shifts. Or that I've decided that tomorrow you're going to pay me 30% more. The employee couldn't do that. Well, by the exact same token, the employer cannot do that. Your employer cannot decide tomorrow that you're working night shifts instead of mornings. They cannot reduce your pay. They cannot say that from now on you've been demoted. If they do, that's a constructive dismissal. If you find yourself in that situation, please give me a call and let's discuss it.
And that is, by the way, 1-855-821-5900. The next point is this: an employer must accommodate medical conditions.
This is such an important obligation that an employer has, such an important right that every employee has, and that is the right to be accommodated if there's a medical condition. Now, there's other rights to accommodate that are tied to other things, religious beliefs, etc. But really, when it comes to medical condition, that's probably the most common area that people will face, where you may have a medical condition, you may have a limitation, and you need some help from your employer. Maybe you need modified hours, maybe you need modified duties, maybe you need the ability to work from home. Whatever that is, your employer has to find a way to make it happen if it's legitimate. If you have a doctor's note supporting you, your employer has a very strict duty to accommodate. It doesn't matter if it's difficult. It doesn't matter if they don't really want to. They have to make all efforts. And if they don't want to and they don't try, that's a human rights violation. Call that a failure to accommodate. That's a very big deal. Now, of course, everything has its limits, and there could be situations where the accommodation that you need is so extreme that the employer is just not able to do it. Okay, in that extreme situation, that's fine. But I've seen, John, thousands of matters over the years where the employer could have accommodated but chose not to. They didn't want to go there. They didn't want to put themselves in that situation. That's illegal. If you have a doctor's note, if you need to be accommodated, tell your employer. If they refuse, let's talk about it. I can usually get this resolved, give them a kick in the pants to make sure that happens. You have the right, your friends have the right to be accommodated if you have a medical condition.
And I would imagine that threshold that they have to meet gets higher the bigger the company, the more resources they have, right?
Absolutely. It's going to be very difficult for a company with lots of employees and lots of positions and lots of resources to say, oh gosh, we just can't accommodate you. We have nothing for you. That's not going to ring true. On the other hand, if you're working in a corner grocery store with one or two other employees, an employer may struggle to accommodate more, but either way, an employer has to try to accommodate if possible.
We are talking about the employment rights your friends and family and you need to be aware of. This may affect a lot of people, Lior, and you are likely not an independent contractor.
Yeah, in fact, I would have said even, you're just not an independent contractor, because the vast majority of people are misclassified. Later today, I have a call with someone who sent me their contract saying that they're an independent contractor. Well, no, they're an employee. Why? Because they work full-time for the company. They have a job, they go to the office, they do their job, they go home and come back the next day. That's an employee relationship, an employee-employer relationship, not an independent contractor. Most individuals are misclassified. So if you have a regular job, you are an employee. It doesn't matter what you call yourself. It doesn't matter what you sign. It doesn't matter how you pay your taxes. Doesn't even matter if you've incorporated and are charging GST, HST, PST, doesn't matter. So chances are you are misclassified, and that's important because there's certain entitlements that you have. Number one, you may be entitled to overtime, vacation pay, minimum wage, statutory holiday pay. But even more important potentially is if you lose your job, you're going to be entitled to your full severance, up to 24 months pay. So if you lost your job and you believe that you're not owed severance because of the fact you were quote unquote an independent contractor, chances are you are an employee and are owed severance. If you want to find out, by the way, if you are an employee or an independent contractor, I mentioned pocketemploymentlawyer.ca. Well, we have a tool there, again, free and anonymous, that allows you to find out if in fact you're an employee or a contractor. So check it out at pocketemploymentlawyer.ca.
Well, you mentioned the word severance there a couple times, and that's another right you need to be aware of, and that is you do not have to accept that severance offer by the deadline offered on the severance package, right?
Absolutely. So every severance offer has a deadline. You know, we need you to accept this offer by Friday at 5 or by Thursday at 5, whatever that date is. That date is meaningless. Your rights don't expire on that deadline. Okay, you have 2 years to pursue it. That's just a pressure tactic. Ignore it. It does not matter. You have to make sure you're getting what you're owed. And you do that before you sign, not after. Because once you've signed, and then if you realize, my gosh, they owed me another 10 months pay, it's too late to do anything about it. Okay, so that's why you find out what you're owed, you call me. You go to pocketemploymentlawyer.ca and use our calculator there. But either way, do not sign. Your rights don't expire. It's not going to go anywhere. So please be smart and tell others. You may be speaking to your brother-in-law and they say, well, I have to sign the severance offer by Friday. Tell them, no, you don't. You don't need to, not at all. That Friday deadline is meaningless.
Last one before we get to another phone call is this: Severance Know-How 101. You were not owed 1 week or 2 weeks severance for every year. Not true.
No, not even close. That is probably the most basic thing I want employees to remember. It's not a week's pay per year of service or 2 weeks pay or any formula like that. It's a lot more than that for the vast majority of employees. For some employees, that could be a month per year, 2 or 3 months per year. It depends on your age, your position, and the length of your employment. So let's forget about this nonsense of a week per year of service. It's just not true. You lost your job, you want to know how much you're owed, go to pocketemploymentlawyer.ca. You can do that now in seconds. No one's even going to know you're there. Or you can call or email me, and I'll tell you what you're owed, but it's not a week per year of service.
Okay, let's grab one more phone call from our radio show and see what they got to say.
I have an employee who's off on maternity leave, and her job is no longer available for her to come back to. So I'm wondering what my obligations are.
Tread carefully on this one.
Yeah, very carefully. So the first thing is we want to know how long is it going to be before the employee is ready to come back to work. And the reason I'm saying that is if this employee is not even scheduled to come back for another 9 months, you don't know if you're going to have a job for this employee 9 months from now. Today you may not have a job, but it doesn't matter because this employee is not coming back today. They're not going to be back for a number of months. So what you do is you tell your employee, I may not have a job for you now, but don't worry about it. I'm going to try whatever I can to find a job for you when you're ready to come back to work. If at that time you still don't have a job, you've looked, you've tried, there's nothing, then you can terminate with severance. But don't be too don't be too proactive about it. Let's put it that way. Don't get ahead of yourself when the employee is not yet ready to come back to work. Remember, you do have to take an employee back to work after a maternity or parental leave if that's possible. If the job is there, even if someone else is doing that job now, too bad, you have to bring them back. On the other hand, if the job doesn't exist, you've eliminated the job or you shut down the department, yes, then and only then can you terminate, but only if you know for a fact that when the employee is ready to come back to work, at that time, there's no job. And if you are an employee and you're not ready to come back to work yet, it's going to be months, and your employer is telling you we're terminating today because we know that 8 months from now, we're not going to have a job for you, that's arguably a wrongful dismissal. That's a human rights violation, maybe. That's a violation of the Employment Standards Act. It's illegal. Okay, so you want to give me a call if you ever find yourself in that situation.
Lots more to go, but we'll take a short break before that. 1-855-821-5900 and pocketemploymentlawyer.ca. Go there as well. We're right back. More Employment Law Show. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think contractors aren't owed severance. Employmentlawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at employmentlawyer.ca.
All right, welcome back. Thanks for hanging around. Employment Law Show and employmentlawyer.ca, the website from where we get our phone calls from our radio show. Lior, phone call number 3. We still got a couple minutes coming right now.
I have 2 friends that work in a long-term care facility in the kitchen. The supervisor indicated that they had no budget to hire somebody. And what he had done was he, in fact, went and hired somebody. But what he did was he was taking the hours from them in order to pay for the new person. There's about a 20 to 25% reduction in the hours. They said, well, why don't you take hours from the other people? And his answer was, because you have no rights.
Well, again, maybe something in the back of a cereal box where this employer found out that somehow they know about employment law. Employees have rights. Employees have extensive rights. Doesn't matter what province you're in, you have extensive rights, including the right not to have your pay cut. And if this person is going to lose 20, 30, 40% of their pay because the employer is doing something in the workplace, that's illegal. You have rights, and in fact, this employee can choose to treat this situation as a constructive dismissal. It's a pay cut. It's what it is, any way you phrase it. And a pay cut, unless it's very minor, a pay cut generally is not allowed. So not only does this person have rights, they can get as much as 24 months' pay. Please don't believe anyone that tells you you don't have rights. You have substantial rights. One thing we do really well in Canada, believe it or not, is protect employees, employee rights. So you do have quite good rights.
Now, the one thing I guess this employer could have done way back when is kind of work this into an employment contract before this person started to say they have the right to change their pay, whatever, right?
So we have this concept, in law called freedom to contract. Meaning you can agree to a lot of things if you agree to it, if you sign a document that does it. So one of the things you can agree to in an employment agreement is to give your employer the right to change your pay, to change your hour, to change your job. So if you sign an employment agreement that gives your employer that right, that power, then they can do that. But they can only do that if you've agreed to it, if you sign that document. So an employer may, when they offer you a job, ask you to sign an employment agreement. And one of the things it does is it gives the employer all kinds of powers. So you have to be very careful with what you sign. You don't want to sign something and later on is going to come back to haunt you. But without you signing something like that, your employer cannot take away your rights. Your employer cannot make changes to your job. Your job is what it is. And your employer that tries, or an employer that tries to change those terms of employment, is going to find itself on the receiving end of a constructive dismissal claim. So no, your job is what it is and cannot and should not be changed.
Having said that, if you do have an employment contract or just signed one, you might want to send that to Lior just to see if it even passes the sniff test as far as being legally and properly written. So you can do that. Help at employmentlawyer.ca on email to do that, and call 1-855-821-5900. We will catch you next time. Employment Law Show. Thanks for sticking around with us.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.
People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.